Can I get a court order to force my children to come back to me? This scenario arises frequently in Utah family law and elsewhere, but I will respond in the context of Utah family law. A married couple or an unmarried couple has children. Then this couple divorces or separates, and there is a fight over custody of their children. The parents go to court and fight over the child custody and parent time awards, and the court makes and issues its child custody and parent time orders. But then the children refuse to follow the court's orders, meaning that if the court ordered the children spend the majority of their time with mom, for example, and get to see their dad, for example, every other weekend and a few hours each week and maybe some holidays, but the children refuse to follow that schedule and go to, for example, dad's house and say they are staying put, not coming back to mom's house. There was a time when I would have told you that in these situations, there's effectively not much the snubbed parent can do about it, even if that is the court-ordered custodial parent. After a certain age, kids become essentially ungovernable by the courts. If the children don't want to follow the schedule the court ordered, there is, or at least I thought there is, little that the court can do to force them to do so. Or so I thought. I recently had a case like this arise. Mom was awarded custody of the children in the divorce action. The children had a falling out with their mother. It doesn't really matter in this context whether the falling out was justified or not. So the kids went over to their dad's house and refused to come back to mom's house. If mom had come to me asking what she could do to get her kids back, I'd have told her that in my professional opinion, there isn't really much I could do, because I was of the opinion up until just recently that courts won't issue orders forcing children to go back to live with a parent with whom they don't want to live, unless of course the parent with whom the children want to live is clearly a danger to himself or herself or to the children or both, whether that be physically or emotionally or psychologically. But I was mistaken. Mom did get the kids back, and against their wills. How? With a writ of assistance. Now I know what a writ of assistance is, and by the time this video is finished, so will you. I just didn't think the court would use one in this way. Utah Code Section 78A-5-102, entitled Jurisdiction of the District Court and Appeals, provides in pertinent part, in subsection 1, quote, except as otherwise provided by the Utah Constitution or by statute, the district court has original jurisdiction in all matters civil and criminal. 2, a district court judge may issue all extraordinary writs, see, writs, writ of assistance, and other writs necessary to carry into effect the district court's judgments, orders, judgments, and decrees. Sorry, district court judges, orders, judgments, and decrees. 78A-5-102 either empowers or recognizes the power of a court to issue a writ to enforce child custody and parent time orders. The Utah courts even provide guidance and forms for people to use to facilitate obtaining such a writ. You can access that information in the writ of assistance by using the links I will provide in the description section of this video. But before you think that you can run out and get a writ of assistance to get your kids back, if they refuse to obey the court's custody and parent time orders, bear in mind, I've been practicing divorce and family law for more than 25 years, and in that time I've witnessed a court issuing a writ of assistance to enforce custody and parent time against non-compliant children once in 25 years. So while 78A-5-102 of the Utah Code can enable you to obtain custody of your children by force, that doesn't mean you will succeed in obtaining custody of your children by force through the application of a writ of assistance under Section 78A-5-102 of the Utah Code.